Hey everyone, this is Laura, the real Laura B here on YouTube and Twitter. I am here today on more of the Unsealed document series. Today we're going to be talking about is how Johnny Depp was able to get Amber Heard to submit to an IME, an independent mental examination with Dr. Curry. So that's what we're going to be talking about today and a few of the documents. Hang on, we'll be right back.
Hi, I'm Laura, also known as the real Laura B from Twitter and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Welcome back. Yeah, so we did see a motion that had been filed by the Depp team. We never saw the explanation of why it should happen. We never saw the order, whether it was going to happen in part or at all. And that all came out in the Unsealed documents. So that's what we were going to talk about today, is how this came about. And just a reminder that Amber Heard had far earlier on under Judge White tried to get Johnny to be compelled to sit for an IME, and they were denied because he wasn't putting his mental health on the table as far as his claims. But Amber Heard did when she brought in her own expert witness, Dr. Hughes, who was going to testify that she had PTSD. That was the ringing of the bell that Johnny was able to get Dr. Hughes in. So let's take a look. This is his initial request. It was filed on September 3rd, 2021. It's pretty much replicated in the memo. So why don't we just start with the memo to support their desire to compel her to sit for an exam. This is filed under the protective order. Plaintiff Depp hereby moves the Honorable Court, per Virginia rules, to require Amber Heard to submit to an independent mental exam by a qualified healthcare provider of Mr. Depp's choosing, which is the same request she had made when she was going to have Dr. Spiegel actually examine Depp back when her original request with Judge White. In short, Ms. Heard has placed her mental condition directly at issue in this case. Her expert disclosures include proposed testimony from a clinical and forensic psychologist, Dr. Dawn Hughes, who will apparently testify at length about Ms. Heard's purported post-traumatic stress disorder, PTSD, and intimate partner violence, IPV, and related behaviors. Dr. Hughes' assessment of Ms. Heard's mental condition was based on multiple psychological examinations and interviews with Ms. Heard. While Mr. Depp had no intention of requesting such an exam in this case, Ms. Heard's expert disclosure leaves him no choice. In order to meaningfully rebut Ms. Heard's proposed expert testimony and to defend against her allegations in the counterclaim, Mr. Depp must be afforded his own opportunity to examine Ms. Heard's mental condition through an expert. Thus, the court should either require that Ms. Heard sit for a medical exam or alternatively strike her proposed expert designations. And here's the background. The court may be aware that this is not the first time in this case that a request for a medical exam has been submitted to the court. Back on November 1st, 2019, Ms. Heard brought a motion demanding a Rule 14 exam of Mr. Depp. Former Chief Judge White denied Ms. Heard's motion in the November 15th order, finding there was no good cause shown for an IME in this case. In his successful opposition to Ms. Heard's motion, Mr. Depp correctly pointed out that his mental condition was not in controversy as required by the Rule 410, while Ms. Heard attempted to unilaterally make Mr. Depp's condition an issue, where Ms. Heard argued in her own declaration that Mr. Depp had a history of drug and alcohol abuse, had temper, etc. Mr. Depp did not assert that he was suffering from PTSD or any other mental condition as a result of Ms. Heard's defamatory statements that would call his mental condition into question. Contrastingly, as discussed in further detail below, Ms. Heard has asserted that she suffers from PTSD and other mental conditions purportedly as a result of her relation with Mr. Depp and Mr. Waldman's public statements. So this is important. This is coming in predominantly because of the counterclaim she filed. Thus, it is Ms. Heard, not Mr. Depp, who has made the strategic and calculated choice to put her mental condition in controversy. As a result, Mr. Depp's counsel has spent weeks attempting to meet and confer with Ms. Heard's counsel to set up a medical exam. Those efforts have been unsuccessful. Surprisingly, rather than producing Ms. Heard for an exam, Ms. Heard's counsel has instead renewed her demand that Mr. Depp sit for an exam. Once again, Mr. Depp's mental condition is not at issue in this case. Nothing has changed since the court denied Ms. Heard's November 19th request, and her renewed demand is nothing more than a transparent attempt to harass and intimidate Mr. Depp. Faced with Ms. Heard's irrational stonewalling, Mr. Depp is forced to bring this motion to ensure that he can fully and fairly dispute the proposed testimony of Ms. Heard's expert. Argument: Ms. Heard's mental condition is in controversy and good cause exists to grant the motion. Here's the relevant part. When the mental or physical condition of a party is in controversy, the court in which the action is pending upon motion of an adverse party may order the party to submit to a physical or mental exam by one or more healthcare professionals employed by the moving party. That would be Depp. The order may be made only on motion for good cause shown and upon notice to the person to be examined and all parties. Whether to award the examination is in the sound judicial discretion of the court on a showing made. Here, Ms. Heard has placed her mental condition squarely in controversy, and good cause exists to grant Mr. Depp's motion. According to Ms. Heard's expert disclosures, Dr. Hughes says, was asked to conduct a forensic psychological evaluation of Ms. Heard to assess for the dynamics and consequences of IPV that may have been present in her relationship with her now ex, Depp, and to assess for any psychological consequences stemming from the defamatory statements to the media made by Mr. Depp through his attorney agent, Adam Waldman. That's the counterclaim. Thus, Dr. Hughes' testimony will be used both defensively against Depp's complaint and offensively in support of Ms. Heard's counterclaim. Dr. Hughes also will purportedly testify, among other things, that results from psychological testing suggest Ms. Heard is not malingering or feigning psychological difficulties. The overall impression of objective psychological testing suggests several clinically significant difficulties for Ms. Heard that likely caused notable impairments in functions. Ms. Heard's responses on the PCL-5 support a DSM-5 diagnosis of PTSD and an etiology of the intimate IPV. Ms. Heard endorsed symptoms in all 4 clusters of PTSD, intrusive reminders of the trauma, avoidance of reminders of the trauma, negative alterations in cognition, and moods and alterations in arousal and reactivity. Ms. Heard's expert disclosure for Dr. Hughes goes on to discuss in much greater detail each of those purported findings. In light of this proposed expert testimony, Ms. Heard has unquestionably placed her mental condition at issue. Indeed, Mr. Depp obviously disputes these assertions. Any purported PTSD or IPV-related behaviors allegedly suffered by Ms. Heard cannot be caused by Mr. Depp because he did not abuse Ms. Heard. But Mr. Depp's ability to effectively dispute this expert testimony would be significantly prejudiced should he not be afforded an opportunity to conduct his own examination of Ms. Heard. Mr. Depp is entitled to explore 1, whether Ms. Heard is in fact suffers from the alleged mental conditions, 2, the possible root causes of such mental conditions. Accordingly, good cause exists to grant Mr. Depp's motion. Good cause further exists because Dr. Hughes' purported testimony is based on 25 hours of psychological examination and a battery of tests, to which Ms. Heard willingly submitted in a strategic effort to bolster her defenses and counterclaim. Once again, Mr. Depp did not put Ms. Heard's mental condition at issue. Ms. Heard did. It would be painfully unfair if Ms. Heard were allowed to use this proposed testimony as a sword without also offering Mr. Depp an opportunity to conduct his own IME to explore the factual underpinnings of the accuracy of Dr. Hughes's assertions. So just a footnote, the length and extensiveness of Dr. Hughes' examination, 25 hours spanning 5 separate testing sessions, necessitate a similar period of testing by Dr. Curry. While 25 hours is excessive, Dr. Curry believes that 14 hours will be necessary and sufficient to perform the required examination. A preliminary investigation of Dr. Hughes' findings reveal some serious deficiencies, and to ensure that the questions regarding Ms. Heard's mental conditions are adequately addressed by scientific evidence that is valid, measures what is intended with accuracy, and reliable, consistent over time and circumstance. A re-examination of Ms. Heard is warranted. Dr. Curry's re-evaluation of Ms. Heard will utilize the same tests that were administered by Dr. Hughes, with the caveat that any instruments which are identified as possessing poor retest reliability, variability in results if the test is taken again, or validity concerns will be substituted for measures with greater established validity and reliability. Another critical aspect of assessing the accuracy scientific basis of Dr. Hughes's conclusion is examining the raw data collected by Dr. Hughes during her examinations. For that reason, we also asked the court to require Dr. Hughes to produce the raw data underlying her conclusions. Production of raw data is standard practice anyway. So it is one of the basic pillars of discovery that parties may obtain discovery relating to another party's claim or defense. Here, Dr. Hughes's testimony is clearly going to be a significant part of both Ms. Heard's claims and defenses. Dr. Curry is qualified to conduct the IME. She is further provides that such an examination can be conducted by a healthcare provider who is not licensed to practice in, is not a resident of, does not have an office in Commonwealth. So they do attach an exhibit of her entire curriculum vitae or resume, all her qualifications. So she's more than qualified to be able to do this. Moreover, Virginia Code waives license requirements for testifying psychological experts. And that was a big deal because remember, Elaine Bradehoff tried to make that a big deal, finding what she's licensed in, what she's registered in, what her, all those qualifications. Stating that requirements for licensure provided for in this chapter shall not be applicable to any person duly licensed as a psychologist in another state who testifies as a treating psychologist or is employed as an expert for the purpose of possibly testifying as an expert witness. In sum, Ms. Heard made the strategic choice to place her medical condition in controversy, and good cause exists to grant Mr. Depp's motion for an IME. Should the court require that the healthcare provider be licensed by the Commonwealth, Mr. Depp respectfully requests that he be afforded an opportunity to find a suitable replacement. So I'm not going to have to get into all the exhibits. There's pages upon pages of Dr. Curry's qualifications. There's also prior transcripts when she tried to get Johnny to sit for this test and how the judge disagreed. And that was helpful, I think, to refresh Judge Ascarati's mind in what the prior ruling was. But I don't think we need to read all of that. So let's get into the opposition that Elaine filed saying, no, heck no, our client shouldn't have to do this. Ms. Heard opposes Dr. Depp's motion to compel a Rule 410 exam. An exam that would be in no way independent because Mr. Depp will not agree to a 410 exam of him. Well, he's not putting his mental health at controversy, and that was already ruled on. So she's saying tit for tat. If you're going to make her sit, then you have to sit, and that's not the way it works. Ms. Heard simply seeks fairness for both sides to be treated equally, which Depp refuses to allow. As will be shown below, both parties are in the same position in this litigation. They both have claims of defamation, and both parties designated experts related to medical and mental health issues. A legally consistent and equitable approach requires that both sides be allowed a 410 exam of the other under the same conditions, or neither side be allowed of the exam. A legally consistent and equitable approach is all Ms. Heard seeks. Well, Johnny's not claiming PTSD. He's not claiming IPV because he's saying, I didn't harm her. Mr. Depp's motion falsely claims Ms. Heard has placed her mental condition at issue, while Mr. Depp has not. The truth is that both sides have designated medical experts who opine on each party's mental health. These designations have either placed both of their mental conditions at issue, or neither has. In opposing Ms. Heard's prior request, November 2019, to take a 410 exam of Mr. Depp, counsel from Mr. Depp argued it should not go forward because there is no freestanding claim for either intentional or negligent infliction of emotional distress, as there are counts. These are counts for defamation. And this came up in some of the threads that we saw that were trying to claim that, hey, Johnny never claimed that he was abused. Well, no, as part of his legal argument, he was only filing against defamation. His testimony came out what he experienced, but his legal filing was strictly for the count of defamation. Ms. Heard is in the same position. Yes, Mr. Depp is requesting a 410 exam of her. Ms. Heard has no freestanding counterclaim for either intentional or negligent infliction of emotional distress, just like Mr. Depp. Ms. Heard has a counterclaim for defamation. Since these claims are the same, the parties should be treated the same. Well, she's already stated that Dr. Hughes is going to testify that she suffers PTSD from those claims, those statements by Adam. At the hearing related to Ms. Heard's first request for the exam of Mr. Depp, former Chief Judge White held, the request seems to me to be an effort to have a medical assessment by an expert who would then be offered as a witness to testify as to the credibility of one of the parties. And I don't find that to be appropriate or helpful, because Mr. Depp wasn't claiming, there was none of his mental health was in controversy in his claims. Amber Heard was the one claiming PTSD and IPV. Now Mr. Depp seeks to have Dr. Curry perform a 410 exam on Ms. Heard, even though Dr. Curry already concluded that Ms. Heard exhibits patterns of behavior that suggest her allegations of abuse against Depp are false. It is plain as day that Mr. Depp is seeking to use Dr. Curry to testify as to the credibility of Ms. Heard from former Judge White held was inappropriate. And I think what's happened is once Elaine Amber Heard submitted her expert witness, Dr. Curry, and what they intended to testify to, Johnny sought out Dr. Curry and said, hey, look at this, and what do you think of what they're claiming? So that's why she started to form opinions about why she should be able to also conduct an IME. Mr. Depp claims he needs Ms. Heard to undergo a 410 exam because Ms. Heard has placed her mental health at issue when Ms. Heard designated Dr. Dawn Hughes as an expert who will testify to the PTSD Ms. Heard suffered from the domestic partner, the DV, she endured from Mr. Depp. As an initial matter, an expert testifying as to PTSD Ms. Heard suffered is not opining, as Dr. Curry apparently seeks to do, on the truth or veracity or felicity of Ms. Heard's claims that Depp abused her. She is simply expressing an opinion on Ms. Heard's PTSD. While the jury is entitled to hear and evaluate as the ultimate fact finder, but if Ms. Heard placed her mental health at issue with the designation of Dr. Hughes, then Depp has placed his mental health at issue with his expert designations. Dr. David Kipper, who Depp identified as his expert disclosure, has served as Mr. Depp's treating physician for more than 6 years. Diagnosed Depp with primary dopamine imbalance, ADHD, bipolar, depression, etc. Dr. Kipper's deposition at Mr. Depp's counsel request, Dr. Kipper testified that these were his diagnoses and he possessed the qualifications to make these diagnoses. Now, I'm going to jump in here real quick because there has been a long, we call this the pretrial battlefield. There were a lot of documents and motions filed in California court where Dr. Kipper's residence is. They subpoenaed him. They wanted him to testify. There was motions filing. And the one thing that the California judge definitely ruled on, that Dr. Kipper could give testimony as a treating physician, but not as an expert witness. Elaine knew this when this is all being filed, because that was many months ago. Dr. Kipper could only testify as a treating physician, not as an expert witness. So that defies this right here. Mr. Depp's expert disclosure states, and this again, he had attempted to have Dr. Kipper as an expert witness, but it was denied a while ago. Dr. Kipper is expected to testify as to the pharmacological effects of the medications prescribed on Mr. Depp, as well as medical opinions reached during the course of Depp and Ms. Heard's treatment. In so doing, Dr. Kipper may rely on his expertise and experience as a medical doctor practicing in internal medicine. Emphasis added, the party's designation of medical experts should be treated in the same way. Mr. Depp argues that Dr. Curry should be able to perform a mental exam of Ms. Heard because Dr. Hughes spent 25 hours with Ms. Heard, and no one from Depp's side has been able to examine Ms. Heard. Yet Mr. Depp will not allow a 410 exam on him, even though Dr. Kipper has treated and examined Depp for over 6 years and claims to have opinions about his medical and mental health, as well as the pharmacological effects of medication on Depp. But no one from Ms. Heard has been able to examine Mr. Depp. If Mr. Depp is allowed to have his doctor of choice examine Ms. Heard should have the same right as Mr. Depp. Mr. Depp plans to have Dr. Kipper testify as an expert to how Mr. Depp's mental disorders and the medications prescribed to Mr. Depp affected his relationship with Ms. Heard, his tendency toward violence, and his memories or lack thereof of the events that occurred to Ms. Heard. Ms. Heard should have the same right. I think Mr. Depp plans to have Dr. Kipper testify how these things did not affect tendencies toward violence. Anyway, that's maybe I'm remembering wrong. Finally, the situation is entirely different than it was in November 2019 when former Chief Judge White denied Ms. Heard's request. At the time of the hearing on November 15th, 2019, Mr. Depp had not identified Dr. Kipper as an expert and claimed at the hearing that Dr. Kipper was only a fact witness. Dr. Depp also had not identified Dr. Curry as an expert to claim Ms. Heard is lying, which is contrary to Judge White's admonition that experts should not opine on credibility. Judge White previously recognized that Depp's complaint alone placed Depp's mental condition at issue, stating, "I think that the complaint is broad enough to place these things in issue, places Depp's mental condition in issue, even though it may or may not really be an issue in this case. Nevertheless, it put in the complaint for a purpose. Since Judge White made his finding based on the allegations in Depp's complaint, Depp has unquestionably confirmed that his mental condition is in fact at issue through his February 16, 2021 designation identification as expert witnesses and Dr. Kipper's deposition testimony." Keeping in mind, Dr. Kipper is a licensed internist, a medical doctor. Anyway, the circumstances have changed by Depp's own making. Indeed, comparing Mr. Depp's expert disclosures of November 4, 2019 before the hearing to his disclosures on February 16th reveals that Mr. Depp now intends to call Dr. Kipper. This is February 2021, so almost a year before, or more than a year before the trial, reveals that Mr. Depp now intends to call Dr. Kipper as an expert on Mr. Depp's psychological disorders and the effects of medication on Depp and his conditions, and further intends to call Dr. Curry to testify as to Ms. Heard's purported diagnosis, to rebut Dr. Hughes's reports. Anyway, just as Ms. Heard identified Dr. Hughes as an expert, Mr. Depp has made a conscious choice to identify Dr. Kipper as an expert. The effect of these choices on whether a 410 exam should be allowed should be the same. Either they both should be precluded from undertaking the exam, or they both should undergo it. Yeah, that's not how it works. If a mental exam is ordered, Ms. Heard requests reasonable conditions and that they be the same for both Ms. Heard and Mr. Depp. She's still pushing that they both should have to undergo this. If a 410 exam is ordered, Ms. Heard respectfully requests that the same conditions be ordered for both. Some of the conditions Mr. Depp proposes are not reasonable. Ms. Heard proposes the following. 410 exam shall never be called or referred to as an independent exam. A 410 exam shall not exceed 14 hours over the course of 2 days, in which each day shall include 1 hour lunch break, 2 15-minute breaks in the morning, 2 in the afternoon, and other breaks as needed, agreed to by the examiner and the party. The 410 exam should be conducted via Zoom, given the risk of COVID Delta variant, to all parties involved, and should not be held in the law firm under any circumstances. Now, footnote here, Dr. Curry is clearly not independent. She's being paid by Mr. Depp. Well, that's how it works with expert witnesses. Amber Heard paid for Dr. Dawn Hughes and all her other expert witnesses, and has apparently already determined without examining Ms. Heard that she is lying. Well, this is one of the things you do. Look, this is the expert witness. This is what her findings are purported to be shown in court. Is this something you can test for? And she didn't agree with what she was reading. Ms. Heard has a new baby who is obviously not immunized, and under the circumstances of COVID, this lessens the risk. We all will agree to the same for Depp. Each party shall be allowed to have the other side's expert observe the examination over Zoom, not on camera. The other side's expert over Zoom. Interesting. This will allow both parties assurances that the 410 exams are conducted properly, especially given the expert opinions already given. The 410 exam shall be conducted during 2 days in either the first or second weeks of December, beginning 9 a.m., or other days and locations mutually agreed upon. The 410 exam shall consist of one-on-one examination and clinical interview and include appropriate testing as determined by the medical examiner chosen to perform the 410. Now remember, they're proposing this because they're also expecting that the court is going to rule that Johnny has to submit to this too. The scope of the 410 exam shall be what is addressed in the parties' expert opinions as designated on February 16, 2021. The Rule 410 examiner shall prepare and serve a report on the other side within 30 days. For all testing administered, the expert shall provide the test questions administered to the party. the answers given by the party, and any computerized analysis of the answers, including any computerized diagnoses. The opposing expert shall provide the same within 5 days after the report is provided to avoid tainting the 410 exam. Medical examiners chosen to perform the 410 exam will make themselves available for deposition for up to 5 hours by Zoom. So what happened was that with these the 410 exam, they got to depose Dr. Curry after she administered the test. They had wanted Dr. Siegel to administer the test to Johnny. Of course, we know it was denied. Ms. Heard simply asked for fairness. Either no 410 should be ordered or a 410 should be ordered for both. And we don't have to get into all the attachments because this is going to be a lot of the back and forth, and that's not really the history of what we're worried about today. However, there was an order. Upon consideration of plaintiff's motion to compel independent mental exam of defendant Amber Heard, defendant's opposition thereto, arguments of counsel are being fully advised on this. It's October 21. Hereby is ordered. Plaintiff's motion is granted. Defendant Amber Heard shall submit to an IME conducted by Dr. Shannon Curry. The IME shall take place on November 1st and November 5th of 2021 at Brown Rudnick's California office, not over Zoom. Each day shall begin at 9 a.m. and continue for a period of 7 hours to include 1 hour lunch, 2 15-minute breaks in the morning and 2 in the afternoon, and breaks as needed as long as Ms. Heard and Dr. Curry mutually agree. The IME shall consist of one-on-one examination and clinical interview between Dr. Curry and Ms. Heard to include appropriate testing as determined by Dr. Curry based on her training, experience, expertise, and review of relevant materials. The scope of Doctor's IME shall be Ms. Heard's current mental condition and her mental condition during and preceding relevant events and timeframes at issue in Mr. Depp's complaint and Ms. Heard's answer and counterclaim. Dr. Curry's evaluation of Ms. Heard will utilize the same tests that were administered by Ms. Heard's expert, Dr. Hughes, with the caveat that any instruments which are identified as possessing poor retest reliability, we talked about that, the variability in the results of the test if taken again, or validity concerns will be substituted for measures with greater established validity and reliability. And Dr. Curry did conduct separate tests that Dr. Hughes didn't. Dr. Hughes relied on a lot of checklists. Dr. Curry's evaluation shall assess all domains that were a focus of the prior exam of Dr. Hughes: personality profile, PTSD, characteristics of IPV, coping and adjustment, psychopathology, including but not limited to assessment of mood and anxiety disorder symptoms, response validity, malingering, and any other mental conditions identified by Dr. Curry during the review of relevant records and or examination of Ms. Heard. Dr. Curry's Rule 410 report shall be filed within 30 days of completion, and defendant shall produce the raw data collected by Dr. Hughes during her examination of Ms. Heard. So it was a slam dunk. This is prior to any of the motions in limine. It was granted. Johnny's was not. I mean, Johnny's motion was granted, but he was not forced at all to sit for a mental exam. So then we come to the unsealed documents. Now, this is the motions in limine, and this is where Elaine again fighting that if she can't keep Dr. Curry's testimony out, it should at least be limited because we already know she had to sit for it. Dr. Curry's deposition was taken. You see, they did have to get to take a deposition after she gave the testing. It was taken March 21st, 2022, so very close to the start of the trial, which was April 11th. During the deposition, Dr. Curry admitted that she did not evaluate and was unable to provide an opinion as to whether Mr. Depp abused or did not abuse Ms. Heard, whether Ms. Heard abused or did not abuse Mr. Depp, and she did not evaluate and was unable to provide an opinion as to whether Ms. Heard suffered any emotional distress as to the result of the 3 defamatory statements made by Waldman that are the subject of the counterclaim. Dr. Curry should therefore be excluded from testifying on these subjects. In addition, Dr. Curry repeatedly referred to the Rule 410 exam as an IME and that her examination of Ms. Heard was court-ordered. Each of these references was designed to suggest Dr. Curry was testifying on behalf of the court while she's testifying at the order of the court. and that Ms. Heard resisted the Rule 410 examination, which is false. No, Dr. Curry is able to examine her at order of the court, and Ms. Heard very much did resist this with her filings. The court has not appointed Dr. Curry as an independent examiner on behalf of the court, and Ms. Heard did not object to providing a Rule 410 exam. Her position was simply that it should be ordered for both parties, which the court disagreed. All right, there you go. Even if Ms. Heard had resisted or opposed the Rule 410 exam, like any opposition to a motion to compel, the fact of opposition is not relevant and would be unfairly prejudicial, confusing, and misleading to the jury, who risk inferring that Ms. Heard has done something wrong, resulting in the court ordering her to be examined by the independent expert. As discussed in greater detail below, but a broader request is being asked here. The use of the term independent is misleading and unfairly prejudicial, as in the reference to court-ordered exam that it was opposed. Dr. Curry, whose initial designation opined that Ms. Heard was lying and abusing Mr. Depp, is far from independent. He was hired by Dr. Depp's counsel, and she even had dinner and drinks at Mr. Depp's home. And remember how all that went. Not to mention the muffins that, God forbid, Dr. Curry was so nice that her husband made that she brought to the exam. And as far as Mr. Depp, Dr. Curry being far from independent, if they had gotten their approval granted their IME for Johnny, they were going to have Dr. Siegel, who was paid by them and provided by them. That's just the way it works. Finally, when asked about attaining collateral interviews for verification and as best parties in conducting an examination and rendering opinions, Dr. Curry contended that this court had ordered Dr. Curry not to engage any collateral sources, citing to the October 8, 2022 order, which is attached. In fact, the language from the order drafted by counsel for plaintiff was stricken by the court because it could have been read to require third parties to speak to Dr. Curry, which was outside the purview of the 410. It did not prohibit Dr. Curry from reaching out to the collateral sources or obtaining their records. In fact, Dr. Curry attended 2 depositions of collateral sources, Dr. Cohen and Dr. Banks, yet did not include any aspect of their depositions in her report and supplement with them. In addition, Dr. Curry was provided with Dr. Hughes' notes, well, that was required, after a mutual order was entered, and did not include those in her report or any supplementation. The paragraph above makes clear that Dr. Curry was not limited by Dr. Hughes' report. Further, provides that relevant records must be obtained as far back as necessary for Dr. Curry to determine with reasonable degree of certainty how Ms. Heard was functioning prior to alleged traumatic event, but not fewer than 3 to 5 years prior to the alleged event, but not fewer than 3 to 5 years prior to the alleged trauma, and indicate Dr. Curry can access a number of areas, including any other mental condition identified by Dr. Curry during her review of relevant records and examination of Ms. Heard. And we heard that in the testimony about histrionic borderline personality disorder, personality disorder. So we heard about both. Defendant therefore requests that Dr. Curry be prohibited from testifying that the court prevented her from contacting or relying on collateral sources or opinions. And that's the end of that. Now, what I found interesting was, and this is in the unsealed documents, she refers to attachment 87. There is no attachment 87. She provided no attachment in her filings. So now we go back to, this is Depp's opposition saying Dr. Curry's testimony should not be limited. Let's see. I think this is from, so this is where it starts here. Ms. Heard argues that Dr. Curry should be excluded from testifying about 1, whether Mr. Depp abused or did not abuse Ms. Heard, 2, whether Ms. Heard abused or did not abuse Mr. Depp, and 3, whether Ms. Heard suffered any emotional distress as a result of the 3 purportedly defamatory statements made by Mr. Waldman that are subject to the counterclaim. Ms. Heard argues that Dr. Curry should be excluded from testifying on these subjects because Dr. Curry admitted that she did not evaluate and was unable to provide an opinion on these subjects. Ms. Heard's motion in limine, which we just read, with respect to the 2 subjects, Dr. Curry did not form such opinions because such opinions are improper for any psychologist to render. As outlined in Dr. Curry's rebuttal report of Dr. Hurd's opinion, it is never the psychologist's task to determine that IPV occurred. Accordingly, Dr. Curry will not testify that, for example, Ms. Hurd abused Mr. Depp. However, Dr. Curry should be permitted to testify on these subjects to the extent that Dr. Hughes does. For example, the court allows Dr. Hughes to opine that, for example, Ms. Hurd abused Ms. Hurd, Mr. Depp abused Ms. Hurd. Dr. Curry should be permitted to testify that such an opinion is improper under the relevant professional and ethics standard. Ms. Hurd objects to Dr. Curry referring to her evaluation of Ms. Hurd as an IME, or court-ordered, as the court noted. An IME is an IME. I'm not changing the name. It's illegal. It's what it's known as. So it is an IME. So that's what it stays known as. And that was in the exhibit of the hearing transcript. While Dr. Curry's evaluation and opinion of Ms. Hurd was ordered by the court, Dr. Spiegel's evaluation of Mr. Depp was not ordered or authorized by this court. See, I told you it was going to be Dr. Spiegel. This is relevant only insofar as it demonstrates that Dr. Curry is following the ethical and professional rules and standards, while Ms. Hurd's retained expert, Dr. Spiegel, is not. Further, Ms. Hurd argues that Dr. Curry is far from independent because she was hired by Dr. Depp's counsel and she even had dinner and drinks in Depp's home. Ms. Hurd's motion in limine number 10, which we've covered, there are no depths to which Ms. Hurd and her counsel will not sink. These statements are inflammatory and irrelevant and should be disregarded by the court. Finally, Dr. Curry should be entitled to testify that the court prevented her from conducting collateral interviews. As is clear from the order, the court drew a line in paragraph 6A striking collateral interviews. The court struck this language from the order after Ms. Hurd's counsel argued that plaintiff added significant substantive language that the court did not order and that was not contained in plaintiff's prior proposed order, including the right of Dr. Curry to interview third parties, which is wholly inappropriate for a 410 exam of defendant. Emphasis added. Ms. Hurd's argument that Dr. Curry's opinion should be limited because she abided by this court's order to not conduct collateral interviews is frankly ridiculous. And I always find it interesting when I read these opposing motions and how things are worded in one saying, oh no, she was able to do this. And they're like, no, we weren't. She wasn't able to do this because that's exactly how the order was and it was struck out. Ms. Hurd's argument that Dr. Curry's opinion should be limited because she abided by this court's order to not conduct collateral interviews is frankly ridiculous. Normally, Dr. Curry would conduct collateral interviews as part of her forensic psychological evaluation. In this case, Dr. Curry was precluded from doing so in the face of Ms. Hurd's and her counsel's strenuous objections. Therefore, it is only fair and equitable that Dr. Curry be permitted to explain the limitations of her psychological evaluations of Ms. Hurd, especially since Ms. Hurd's retained expert, Dr. Hughes, did conduct collateral interviews as part of her forensic psychological evaluation. Dr. Curry abided by the court's order and should not be penalized for doing so. Ms. Hurd's suggestion that Dr. Curry could have simply contacted Ms. Hurd's past medical and mental health providers overlooks a critical detail. These providers would not have been able to speak to Dr. Curry without a HIPAA waiver or a court order, neither of which was provided to Dr. Curry. I wish I had thought to bring it up, but there is a court order that Amber Heard had to sign a HIPAA order, but it was limited to only medical that she received around the time of her allegations of injury. It was only medical. The mental part was crossed out. So she could not have spoken to any of her providers without the HIPAA waiver. For these reasons, Mr. Depp opposes Ms. Hurd's motion in limine number 10. Let's see if there's anything here. So this is, I think we're going to have a lot of, this is going to be a lot of pages of witness experts. So let's see if there's anything. Yeah. No, it's going to be her CV, it's going to be another, because this is part of multiple experts that Amber Heard was trying to negate. They're all filed under the same limine. And again, this is Mr. Depp now. He filed to limit or to exclude expert testimony of Dr. Dawn Hughes. We know this was denied. We don't know how much was allowed, but she most certainly did testify. Plaintiff and counterclaim Depp, by counsel, hereby moves the court to exclude parts of the testimony of Dr. Dawn Hughes for the reasons set forth fully below. So this is their motion of limine to exclude parts of Dr. Hughes's testimony. And I thought that was important and fair to bring both sides in. Ms. Heard's attempt to present certain expert testimony by Dr. Dawn Hughes is improper because parts of Dr. Hughes' anticipated testimony are irrelevant, without foundation, and could only serve to confuse or mislead the jury. Ms. Heard's third supplemental and rebuttal disclosure of expert witness is what appears to have become a pattern for Ms. Heard. Ms. Heard attempts to submit expert testimony to opine that certain disputed conduct has occurred. Just like Dr. Siegel, another expert retained by Ms. Heard, Dr. Hughes opines that Mr. Depp allegedly physically abused Ms. Heard based on cherry-picked evidence that unilaterally supports Ms. Heard's position while ignoring contradictory record evidence and without ever having spoken with Mr. Depp. Dr. Hughes has no valid basis whatsoever to render such opinions. These parts of Dr. Hughes' opinion lack foundation and invade the province of the jury. Furthermore, non-existent probative value is clearly outweighed the unfair prejudice they would cause. So let's take a look at this. Dr. Hughes' testimony regarding conduct that has occurred lacks proper foundation and violates the professional ethical standards. Dr. Hughes intends to provide expert testimony as a forensic psychologist to opine that certain conduct occurred between Mr. Depp and Ms. Heard. This is improper. For example, Dr. Hughes intends to testify that IPV inflicted upon Ms. Heard by Mr. Depp is categorized as severe because it consists of, and if I say these things, YouTube might not be happy with me, but they're not nice things. An increase in frequency and severity of this and serious injuries such as, and we know what she testified at. Mr. Depp also engaged, and emphasis added, in serious SV during instances of rage and violence in which he forced. Other times he forcibly and violently, you know what he did. And I have to be careful because YouTube is going to really get mad at me. In examining the factors present in this case, there is statistical support to suggest that IPV perpetrated by Depp toward her is serious and severe and dangerous. Emphasis added. There were 2 very serious abusive incidents, noting in which Ms. Heard thought Depp would unalive her. The first time in Australia, we know all these, and I have to be careful with YouTube. But this is all what Amber Heard is self-reporting to Dr. Hughes without any extraneous evidence that it actually occurred. Dr. Hughes' opinion that such conduct occurred between Depp and Heard lacks any valid basis or proper foundation. Such an opinion cannot legitimately be drawn from psychological methods and is instead based on cherry-picked evidence which is contradicted by other record evidence. Compare image of Heard purported injuries on May 21st. We saw that from the testimony of LAPD officers. I'm pretty sure they're LAPD officers. I'm pretty sure they were referencing to the 2 photos that were taken at the identical time, the identical tape. You can see they're identical photos, except one has been maybe more saturated or filtered. That LAPD officers walked across broken glass and observed property damage, with sworn testimony of those same LAPD officers that they did not observe any injuries to her face or property damage. So Dr. Hughes is ignoring other testimony that contradict Ms. Heard's claims. Dr. Hughes's opinions also violate relevant professional ethical standards. The previous attached exhibit, Mr. Depp's designation of opposing expert witnesses attached herein. Mr. Depp's retained forensic psychologist, Dr. Curry, has opined that Dr. Hughes repeatedly misrepresents descriptions of IPV between Ms. Heard and Mr. Depp as factual, thus introducing potential prejudice and violating the privacy and dignity of both parties for reasons irrelevant to her purpose as an examiner. To reiterate, it is never the psychologist's task to determine that IPV occurred, emphasis added. Egregiously, Dr. Hughes, like Dr. Spiegel, is seeking to opine about Mr. Depp's mental condition despite never having met or evaluated Mr. Depp. Remember, Dr. Spiegel made a lot of his conclusions from watching Johnny in his movies in character or in interviews. Dr. Hughes's opinions regarding Mr. Depp's psychological instability and the unpredictability, volatility, and severity of his behavior are wholly irrelevant to Dr. Hughes's psychological evaluation of Miss Heard. Dr. Hughes cloaked these personal and pejorative opinions of Mr. Depp as scientifically founded, despite that they are based primarily, if not solely, on Miss Heard's own self-report. Further, Dr. Hughes violated professional practice standards by failing to state the limitations of her opinions about an individual who she did not examine. Taken together, Dr. Hughes's opinions regarding Mr. Depp's mental status and alleged conduct lack proper foundation and violate generally accepted and enumerated standards of psychological practice and should therefore be excluded. Dr. Hughes's testimony regarding her administration of the CAPS-5 on December 27, 2021, 10 days after Dr. Curry administered the test, should be excluded. Dr. Hughes failed to disclose her administration of the CAPS-5 test in her supplemental designation report dated January 11th. On January 20th, 2022, Dr. Curry provided Dr. Hughes with the completed and detailed CAPS-5 from the court-ordered IME and Miss Heard. Dr. Hughes nonetheless waited until February 11th to disclose that she administered the CAPS-5 with Miss Heard on December 27th. Additionally, there are glaring deficiencies in Dr. Hughes' administration of the CAPS-5, including most notably that Dr. Hughes failed to adhere to the standard test procedure, thereby invalidating the entirety of its results. And Attorney Wayne Dennison was excellent in cross-examining Dr. Hughes and pointed out that she wasn't following the instructions. She wasn't totaling up the numbers correctly. She was more or less taking an average. And what was also interesting, if I recall in the tests, she didn't consider Miss Heard's claims of childhood trauma that could have triggered other issues in her life, that should have been tested and scored also. Going on, the first line of the CAPS-5 instructions reads, standard administration and scoring of the CAPS-5 are essential for producing reliable and valid scores and diagnostic decisions. Because Dr. Hughes' administration of the CAPS-5 is utterly deficient, her testimony based on this case should be excluded in its entirety. Now, we did hear her testify to this, and we heard Wayne make sure that the jury knew that she wasn't administering the test or scoring it properly. Dr. Hughes' testimony invades the province of the jury. While expert testimony cannot be excluded on the ground that it invades the jury's decision-making role on ultimate issues, that does not mean, however, that experts can be used for matters of common knowledge. The common knowledge bar rests not on the ground that the expert testimony touches on the core issue of the case, it may or may not do so, but rather than expertise is similarly unneeded, granting plaintiff's motion in limine to exclude the expert's conclusion that defendant had the green light, because that is the inference a layman is equally competent to reach without the unhelpful imprimatur of an expert. Prohibits expert testimony that is speculative or which opines on the credibility of another witness. Astonishingly, as mentioned above, Dr. Hughes seeks to opine that specific instances of IPV occurred. This opinion not only lacks valid basis and exceeds what a psychologist can opine to do, it invades the province of the jury because the jury is equally competent to determine the issue of whether Depp harmed Heard without the unhelpful imprimatur of an expert. And 7 jury members unanimously found that Amber Heard had defamed him knowingly with malicious intent, that she knew she was lying. So thank God for the jury. Further, by passing her opinion on the assumption that Miss Heard's allegations of abuse against Depp are accurate and truthful, Dr. Hughes is necessarily rendering an opinion as to the credibility of numerous other witnesses that dispute Miss Heard's account, including, but certainly not limited to, Mr. Depp, LAPD officers, Tyler Haddon and Melissa Sands, Monroe Tinker, who's a nurse practitioner, Dr. Anderson, and Mr. Alejandro Romero, among many others. The jury does not require Dr. Hughes' assistance in assessing the credibility of evidence with respect to the ultimate issue of whether Depp harmed Heard. Dr. Hughes is opining that the harm actually happened, irregardless or regardless of other witnesses saying, giving just different testimony, that no, they didn't see any injury or damages or at any time. So any probative value of Dr. Hughes's testimony is substantially outweighed by the danger of unfair prejudice and likely of misleading the jury. Finally, Dr. Hughes's opinions would also be excluded because the probative value of her testimony, if any, is substantially outweighed by the danger of unfair prejudice to Mr. Depp and the likelihood that it will mislead the jury. As noted above, Dr. Hughes is proposing to offer damaging testimony about the character and mental condition of Mr. Depp, as well as testimony about what acts have occurred. Such damaging and, with respect to Mr. Depp's mental state, irrelevant testimony should be excluded as unfairly prejudicial and likely to mislead the jury. Well, we know they both got to testify, and we know Wayne did an excellent job. And this is going to be, again, pages of Dr. Hughes's report and CV, and I don't think we need to get into that. So Mr. Depp also has a motion in limine. This came out later on. So this was his motion in limine, and then this is the opposition. Mr. Depp's motion in limine to exclude it. This is Amber Heard opposing this. Mr. Depp's motion to exclude the testimony of Dr. Hughes requested blanket exclusion of her testimony based on cherry-picked sentences that were not her opinions or were partial sentences out of context from the 25-page expert disclosure of Dr. Hughes. Dr. Hughes, a board-certified forensic psychologist, and this was a big deal for Elaine that Dr. Curry was not board-certified, with more than 25 years of clinical and forensic experience, disclosed all her work. She conducted an extensive series of tests on Ms. Heard, conducted multiple interviews with Ms. Heard, her therapist, and family members, reviewed the medical and therapy notes and the extensive evidence in this case, all set forth in her exhibits to the designation. So she must have been finding, in her opinion, that LAPD, for example, was lying. Dr. Hughes' deposition is being taken today for 7 hours. So this is when these were filed. Pre-trial was pretty close to the trial, so her deposition was pretty late. Presumably, Mr. Depp can flesh out any issues and fully examine Dr. Hughes on her opinions, including the basis for the opinions. Moreover, Dr. Hughes' opinions are directly relevant to the claims in this case, as disclosed on page 2 of her disclosure, that Dr. Hughes will testify as to the psychological consequences of Amber Heard as a result of the defamatory statements, including the counterclaim. There's no basis to exclude any of Dr. Hughes' opinion. Dr. Hughes does not opine to the facts of what occurred between Depp and Heard and is based on professional ethical standards. Mr. Depp's brief misrepresents and takes out of context what is actually Dr. Hughes' opinion. In fact, none of the quotes from Mr. Depp's brief are opinions of Dr. Hughes. They are all statements Dr. Hughes recites based on what is being reported to her, which is entirely appropriate under the rules. In fact, Rule 2703A provides, in a civil action, an expert witness may give testimony and render an opinion or draw inference from facts, circumstances, or data made known to or perceived by such witness at or before the hearing or trial, which the witness is called upon to testify. Well, there was a lot of witnesses. As part of that opinion, Dr. Hughes necessarily needs to delve deeper into the issues of DV and IPV in assessing Ms. Heard for trauma associated with the allegation and how this would impact Ms. Heard. Thus, Dr. Hughes is not testifying to the fact that anything happened, but is assessing what is being reported to her and, if true, the significance of that particular reporting. Of course, Mr. Depp's counsel is free to cross-examine Dr. Hughes on each of these statements and the basis for the statements, but they are not her specific listed opinions. In fact, Dr. Curry conducted very similar inquiries, and that is how Mr. Depp justified requesting a Rule 410 to counter Dr. Hughes. But in sharp contrast to Dr. Curry, who opined that Ms. Heard is a liar and the perpetrator, Dr. Hughes is not opining that IPV occurred, but that Ms. Heard has symptoms consistent with an IPV victim, which is completely within the realm of expert testimony in this case. Moreover, since Mr. Depp is attacking Amber Heard's credibility, expert testimony is permitted and helpful to assess from a clinical and forensic perspective how people respond and report in these situations. Testimony will allow jurors to evaluate the alleged victim's behavior, assess credibility, by understanding how individuals generally react to SA. The battered person syndrome is a complex area of human response and behavior. Therefore, expert testimony must be admitted because it supplies the interpretation of the facts, which differs from the ordinary lay perception. Well, I think the LAPD saying they didn't see any injuries or damage is pretty clear. And those are the facts that the jury had, just one of the facts the jury had to determine. As the expert designation disclosed, Dr. Hughes' expert testimony will seek to dispel myths and misconceptions about intimate IPV that are commonly held by laypersons about what the person in such a relationship should or shouldn't do and why these are not correct assumptions. And if I just remembered that Dr. Hughes' testimony appeared to be only about, I'm going to use the male gender against female. The only other time she admitted that two men could abuse each other, but she never opined or gave testimony about females abusing males. Excuse my gender. I don't know how else to describe what I remember being asked in the court. Mr. Depp has offered no case law that testimony as to a clinical explanation of the dynamics of IPV or DV and characteristics as consistent or inconsistent with such issues are inadmissible because the case law allows such opinions. Finally, Mr. Depp claims that Dr. Hughes' opinions violate relevant professional standards. This is based solely on the opinion of Dr. Curry. As the Virginia Supreme Court has held, that it's just a battle of experts, which is the province of the jury. One expert is going to give one testimony, the other is going to do the other. They're going to be slightly biased for each side. That's why they're being hired in the first place. The issue of whether Dr. Erdman deviated from the standard of care, therefore, was subject to conflicting opinions and presented a classic credibility battle among experts. This is citing another case. Conflicting expert opinions constitute a question of face for the jury. Further, it's already briefed throughout the fact that Dr. Hughes did not interview Mr. Depp is not disqualifying, except when she started to give testimony about what she believed he did. Admitting testimony regarding plaintiff's asserted cognitive impairment and need for assistance or verbal cueing without a personal examination is also ethical. A psychiatrist testifies for the state in a criminal case about the competency of the defendant. The psychiatrist based the testimony on medical records and did not examine the defendant nor have the defendant's approval to render their opinion. Was this ethical? The answer was yes. So that's from a prior. So here on the CAPS 5. With respect to the CAPS 5, there's no reason why Dr. Hughes' testimony should be excluded because it was disclosed on February 11th and Mr. Depp offers no basis. Dr. Curry was permitted an extension to disclose her opinions until after the deadline for Mr. Depp's experts. When Dr. Curry provided her opinions, Dr. Hughes then responded and provided detailed findings and testing information. Again, the supposed glaring deficiencies is simply the opinion of the opposing expert and is once again just a battle of the experts. Obviously, Dr. Hughes should be ready to defend her CAPS 5 work, as should Dr. Curry. It is then for the jury to decide. Dr. Hughes' testimony helps the jury. In Virginia, expert testimony cannot be excluded on the ground that it invades the jury's decision-making role in ultimate issues. As the statutes make clear, expert testimony cannot be excluded solely because it involves the ultimate issue or an opinion about facts critical to the resolution of the case. The question is whether the expert testimony is needed. Expert testimony is admissible not only when scientific knowledge is required, but when experience and observation in a special calling give the expert knowledge of the subject beyond that of the person's common knowledge and ordinary experience. Here it is described above, expert testimony on how victims of abuse respond, report, and react is critical to the jury to understand and make determinations about credibility. There is no basis to exclude Dr. Hughes' testimony. It is not unfairly prejudicial. Mr. Depp summarily concludes that the probative value of Dr. Hughes' testimony will be substantially outweighed by unfair prejudice, but this ignores the fact that Mr. Depp will have the opportunity to cross-examine Dr. Hughes at the trial on the grounds for her opinions, and a jury is capable of evaluating the weight of Dr. Hughes' testimony accordingly. It also ignores that Mr. Depp has identified an opposing expert to counter her testimony, which she does. Dr. Curry does get to go up there and rebut her. Dr. Curry was first called by Depp as his witness. Amber Heard called Dr. Hughes For her counterclaim, Depp was able to recall Dr. Curry for rebuttal. For all these reasons, Depp's motions to exclude the testimony should be denied. And we do know it was denied. We don't know whether there was any limitations. What I'm going to present here is just an introduction from Dr. Curry's rebuttal. And my things got stuck. I forgot with audio, I have to share it separately, or you won't hear anything. Or you'll hear massive echoes, one or the other. I have to share it separately or you will hear massive echoes. So let me stop share this and re-present this in a different way. So this is Dr. Curry's rebuttal testimony. It's over an hour long. I'm not playing all of that. I'm only going to play her very beginning.
Ma'am, you're still under oath, so please have a seat, doctor. Good morning.
And I will link this below.
Good morning, Dr. Curry.
Good morning.
Can you remind the jury who you are and what you do?
Sure. I'm Dr. Shannon Curry. I'm a clinical and forensic psychologist, and I'm here today to rebut the testimony that was provided by Dr. Hughes.
Hi, we're all modern. We sell modern
Which
furniture.
of the opinions rendered by Dr. Hughes do you intend to rebut?
So generally speaking, there are three main categories that I'd like to talk about today. So the first is that Dr. Hughes misrepresented the tests and the results that she utilized in her evaluation. She misrepresented my testing and the results that I obtained in my evaluation. And she communicated in a manner, provided testimony in a manner that presented essentially her own opinions and the self-report of Ms. Heard as facts.
Okay, the first category you talked about was the misrepresentation of her own test methods and results. What do you mean by that?
So Dr. Hughes she stated that she administered 12 tests. In actuality, she used 8 checklists. About half of those were symptom checklists. The other half were checklists about experiences that people can have with domestic violence. And those are not appropriate for forensic settings. They are easily exploited.
Other issues that you intend to address relative?
They're easily exploited in that Amber or any person could start to learn what the questions were about and start making their answers to fit the narrative, if that makes sense. Just being a checklist.
To misrepresentation of own results?
Yes, so in addition to using these checklist measures, which are easily exploited in a forensic context, they're developed for research or treatment only. She also stated that these checklists revealed things that they simply cannot reveal, especially in this context. Let's see. She also misrepresented information, clear indications on several of the objective measures that she offered. And there were indications visible that Ms. Heard had essentially engaged in what we call response distortion. So clear indications of exaggeration on one of the measures that's specific to PTSD, clear minimization of symptoms, intentional, on another more broad personality and psychopathology-based measure that she gave to Ms. Heard, which she did not acknowledge.
Did you intend to address anything relative to the CAPS-5?
I did. So Dr. Hughes administered the CAPS-5 about 10 days after I did, almost 2 years after she initially tested Ms. Heard. And she did not administer the test appropriately. So she left major components blank. She didn't apply the scoring rules that are clearly outlined with the test. And yet she diagnosed Ms. Heard with PTSD based on that assessment.
What about Dr. Hughes's use of the personality assessment inventory?
So of the tests that Dr. Hughes administered, 2 would be considered, of those 12, 2 would be considered what we call forensically relevant instruments, meaning that they're objective enough and they provide us with some information about how the examinee approached the test, that it would be appropriate for this setting where the examinee is going to have a natural incentive to present themselves in a way that benefits the outcome of their case. Now, on the PAI, there were clear indications that Ms. Heard was responding and obtained scores in a manner that's consistent with individuals who have a personality disorder. And there was also an indication that several scales, we call this a configuration. So you might have one main scale that you notice is elevated, then you look for additional subscale information to get additional information on what could be elevating that scale. And there was a configuration that showed that even though Ms. Heard had moderately elevated one of the scales that can be associated with trauma, that elevation is better explained by childhood or distant traumatic experiences like the complex trauma Ms. Heard reported experiencing growing up.
And there you go. I'm not going to play the whole thing. Obviously, I can't. I link what I can find about their testimonies, to be fair, in the description box. But I do remember that part that she was talking about scoring the test, that she only scored or asked based on Amber's answers during the time with Depp and did not consider or score childhood trauma that she claimed to also have. So that's what I've got for today. I know it's a longer one, but that's what these Unsealed deep dives are, to get an idea of what was going on behind the scenes that we didn't know about until afterwards. Thankfully, I think Dr. Curry did a great testimony both times. I think Wayne Dennison did great cross-examination, narrowing Dr. Hughes down on her lack of completing the tests, scoring them completely and correctly, and actually showing a lot of, my personal experience in the courtroom, seeing a lot of bias from Dr. Hughes that only women can be abused by men and not men abused by women. And that's certainly how it was coming across to us. So that's what I've got for today. I hope this has been helpful. And I'll keep interspersing some of these in, but I hope we'll have some more positive and current news along the way. There is a lot coming up. Next week is Thanksgiving for me, so I'm not sure if I'll be able to do many videos. It's a big holiday for us. But November 21st, we've got New York Marine has to file. There's going to be a hearing with the insurance lawsuits. There will be a hearing on November 21st. November 23rd, Amber's appeal brief is due. And in Ari Jacobs versus Lorenz in New York Times, their answer is due November 18th. So I've got some stuff coming up, and hopefully we'll have some current events too. So that's all I have for today. Please like, subscribe, and share. I really appreciate the boost and help. And again, reminder, with the community paid for these documents, the California documents that I got on Dr. Kipper and things like that, I paid for myself, and I can't link them because you would not be able to open them. But anyway, have a great day, everyone, and take care.